Hey all, welcome back to the Law Read Slowly. Here we're discussing the Code of Civil Procedure 1908 in a structured and steady manner. So in the last session we were discussing plaint. We had begun discussing plaint in the session before that. In plaint we were discussing how do you write a plaint, what are the organs of a plaint, what are the different parts of a plaint. We began from index, we spoke about memo of parties, then we saw the main portion that is called the plaint in itself as well, which has different parts. We have technical pleadings, we have matters in issue, we have your prayer, we have your verification, we have your affidavit, we have a list of documents, and then you attach your documents and you file your Vakalatnama. In our discussion in the last session, I was telling you how to actually write these pleadings in a plaint, and we saw a couple of examples. We had been working with the set fact scenario that we had taken, that is that there was a contract which was breached by one party, and hence now the other party is filing the suit for specific performance. Based on that, we took examples as to how will you write your technical pleadings, how will you write your matters in issue, how will you write your cause of action, that there is a right which was violated, and now then how will you write your prayer. We wrote a few reliefs for a specific performance suit and saw how do you put it down. Then we wrote verification. At length, I have discussed with you what is verification, what is its purpose, what is an affidavit, then how is a verification different from an affidavit. In its purpose, they're same, but they're two different things. And how, what are the consequences of two things being different, especially in cases of limitation, when you forget to file verification, when you forget to write your verification, when you forget to file your affidavit with your plaint, what consequences will it lead to if you file it after you have filed your plaint by way of amendment. Then we have discussed that the verification itself is considered to be something that can be amended and added to the plaint, and hence even if you amend it later on and add the verification, still the plaint will be said to have been filed on the original date when it was filed. But with respect to your affidavit, affidavit is a document, is a standalone document on its own, but it's supposed to be filed with the plaint. Without affidavit, your plaint is considered to be non-plaint. That is, it's not even a plaint. So whatever you filed on the original date as a plaint without an affidavit was not a plaint. So now when at a later date you are putting your affidavit in, now this date on which you have put your affidavit in has that document become a full complete plaint. So your plaint will be said to have been filed on the date when you file your affidavit. That is a major difference between verification and affidavit. There is a different, uh, you know, barrage of views that exist around this, but these are the most prevalent views, that how will a verification affect your limitation period and how will your affidavit affect your limitation period. So even if a prescribed period has run out, then what happens? We will also write about it today. I will make you write about all the discussion we have had. We will have progress further also in our discussion, and today I will also give you the exact case laws where I have gathered this point from. I will make you write paraphrased holdings of these case laws, but I will also make you write, certain quotations directly from the judgment. I'll pull up judgments here and I'll make you write them so that you have strong material to back your arguments. Then, apart from that, we have had a lot of discussion on how the language of the plaint should be, what should go into a plaint, what should not go into a plaint. Why is it important for you to follow Order 6 and Order 7? Because if you don't follow them while writing your plaint, then despite you filing a plaint which is not following Order 6 and Order 7, your plaint will not be said to have been instituted. Where is this written? It is written in Order 4. We read Order 4, Rule 1, Rule 2, Register of Civil Suits as well, we have read there. And we also, before that, where did we begin the discussion? Section 26. We will read these provisions once again today before we complete them as a discussion. If today, then good, otherwise in next session. But we are going to move at a steady pace, so you keep gathering everything and we will write alongside. Then I believe in the last session I had discussed with you up till affidavit. So let's do this. Let's first read the provision that requires you to file this list of documents with your plaint, and then I will tell you how do you write a list of documents. Fine. Let's go to Code of Civil Procedure. Take out your bare axe, please. Let's go to Order 7, Rule 14. Order 7, what is the title of Order 7? It's plaint. So it's going to talk about plaint. Let's go to Order 7, Rule 14. I hope you're there. Order 7, Rule 14. Production of document on which the plaintiff sues or relies. You have to produce the document. Which document? Not any document. Only those documents on which your plaint is relying, on which the story you are telling is relying. For example, in our example, it will be the contract on which you are relying. It will be, of course, you will also give your ID to the court as a proof that you are the original person who's filing. So maybe you will attach one form of ID. What else? If you're talking about the fact that you as a plaintiff have paid part money, part payment has been done to the defendant by you, then you will attach evidence of that part payment also. What can be the evidence of that part payment? It can be a check, it can be a proof of some other sort. Maybe you sent some kind of other money order, you attach a copy of that money order. Let's read the provision. Order 7, Rule 14. Where a plaintiff sues upon a document or relies upon a document in his possession or power, so a document which is in his possession or power. Of course, if you don't have the document, how can you be expected to attach it with your plaint? If you have the document, only then will you be able to attach it with your plaint. Again, where a plaintiff sues upon a document, so sues upon a document is one thing. So there was a contract. On the basis of that contract, you are suing the defendant, or relies upon a document, the check, the money order, etc., on which you're relying to establish your facts, or relies upon a document in his possession or power in support of his claim. He shall enter. What should he do with such document? He shall enter such document in a list. That is, first he should prepare a list of documents and shall produce it in court when the plaint is presented by him. And he should also present such document in the court along with the list in the court. How will he present it? By attaching it with his plaint. It's written, right? When will he produce and present it? When the plaint is presented by him, and shall at the same time deliver the document and a copy thereof. Of course, I've told you the importance of filing copies of things in the courtroom, because there are different actors who play part in your civil suit. So all of them need to have access to the documents that you're filing, and everybody can't have the original. By the very fact that it's an original, it will only be one. So you need to file copies. You will file a list of documents, you will file the original document, you will file the copy of the documents to be filed with the plaint, that is, with your plaint. Sometimes in practice, what happens is the plaintiff will attach, copy of the documents with their plaint, and they will attach a list of documents, but they will not file the original. Maybe they need the original for something. Maybe they are still some kind of other stuff that they're doing, where they require the original for that purpose. But the rule is that you have to give the original to the court. But you can delay this giving of original till when? Till the settlement of issues. Before this, because of course I've told you, settlement of issues happens when court has seen everything, documents, the pleadings, and everything. So your document has to reach the court in original before the settlement of issues. And with your plaint, sometimes people just attach copies and then they give original to the court later on. I will make you read that provision also where it's provided. So we have discussed that in the plaint, you will attach a list of documents, original documents, and your copy. Subsection 2. Where any such document is not in possession or power. I've told you, of course, if you don't have something with you, how are you expected to attach it? So what do you do? But you still, it's not like, so if you want to rely on some document and the document is in possession of the defendant, maybe when you entered into a contract, you didn't make 2 original copies, you only made 1, and then defendant is the one who has that original document, the contract. Then what do? A document, where any such document is not in the possession or power of the plaintiff, he shall, wherever possible, state in whose possession or power it is. So what will he do? He'll tell the court in his plaint that I'm relying on this document, but I'm not attaching this document because I don't have it, and I don't have the power also to get it. So I'm telling you who has it. Now the court has a lot of power. Court has section 165 Indian Evidence Act, 168 Bharatiya Sakshya Adhiniyam. Court has CPC powers. Court can summon that document from whoever has it. So court can send that person summons to produce that document in the court. We've seen order 16. We've seen order 18, powers of the court. Then so court will call for it. A document which ought to be produced in the court by the plaintiff when the plaint is presented, or to be entered in the list to be added or annexed to the plaint, list of documents, but is not produced or entered accordingly. So suppose you had the document as a plaintiff, you have the document, you have talked about it in your plaint, but you have not attached it in the plaint, you have not added to a list of documents. So what happens now? You were supposed to do it, you haven't done it. Now you can't be allowed to play with justice in your own manner. Now, some extra steps will have to be required by you if you want that document to still be admitted. Because if that is something in your favor and you have skipped on adding it to your plaint, then it's your mistake. You have to bear the brunt. So what will be done? A document which ought to be produced in court by the plaintiff when the plaint is presented, or to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, then what? Shall not, then you will not be what? Allowed to file that document in the court without what? Without the leave of the court be received in evidence on his behalf at the hearing of the suit. Leave of the court means special permission that you have to seek from the court. You have to explain to the court, why did you fail to add that document with your plaint in the first place? Why did you fail to mention that document in your list of documents in the first place? After hearing you, the court will grant you the leave, grant you the permission to file that document now. Once that permission has been granted, only then can the document be taken as an evidence in your favor. Then subsection 4, nothing in this rule shall apply to document. What is said in this rule? What is applying in this rule? First of all, we have to be clear on that. This rule is saying you have to attach all the documents that you are relying upon during the suit with your plaint. But there are some documents which you don't need to attach. What are these? These are being told to you in the subsection 4. Nothing in this rule shall apply to document produced for what? There are two purposes for which you can use a document, and if a document is being used for those two purposes, then you're not required to attach it with your plaint. What are these two purposes? Produced for the cross examination of the plaintiff's witnesses. I will keep this in mind. I'll make a correction here. I'll tell you, for the cross examination of plaintiff's witnesses or handed over to a witness merely to refresh his memory. Now understand this. It says for the cross examination of plaintiff's witnesses. Who is being spoken about in this order? Plaintiff. Plaintiff will cross examine whom? The opposite party's witnesses, that is the defendant witnesses. Then why are they writing cross examination of plaintiff's witnesses? Plaintiff will not do cross examination of his own witness, he will do examination in chief of his own witness. So this is a typographical error in the law, and this error has been recognized in that same landmark case, Salem Advocate Bar Association Tamil Nadu versus Union of India, delivered on 2nd August 2005, Supreme Court, 3-judge bench, judgment delivered by Honorable Justice Y.K. Sabharwal. There the court has said that there's a typo in the Bare Act, and you will read this word plaintiffs as defendants, because plaintiff will be cross-examining the defendant's witnesses. So any document that the plaintiff is going to use while cross-examining, while questioning the opposite party's witnesses, those documents need not be attached with the plaint. Logically, if you're already giving them that document with the plaint, they will already think about it and prepare their answer to whatever is being done in that document. The point of cross-examination is that you need to take that witness by surprise and present to them that document and show them, see, this is what you have said, but I have a document where this is being said. Now what do you have to say? Now answer to the court. So that element of surprise needs to be there. So the law is allowing you to not put that document with the plaint. So you need not put that document with the plaint, which you're going to later on use to cross-examine the opposite party's witness. Or second purpose, handed over to a witness merely to refresh his memory. Now suppose you are calling a witness to testify with respect to some fact, that whether the witness, so suppose your witness is a official, and this case is about contract. So contract was registered. So when you registered that contract, the registering authority officer has signed and registered it. Now when that officer comes to the court, and suppose the officer says in the court in his examination, defendant has brought him to say that this contract was not properly registered and the law required it to be registered for it to be performed. Now this officer comes to the court, and in his examination in chief, he says that yes, this document is not registered. I, as a registering official, am saying that this document is not registered. Then you will take out that document, present to him, and say that, see, you said that it is not registered, but here I have a copy of the registration, and you have signed this copy of registration. That is your cross-examination. So he will cross-examine. Now, how is refreshing of memory different? Suppose